Hear ye, hear ye, hear ye. All persons that think to do for the Honorable Justice of the Appeals Court, now sitting in Boston, Virginia, for the Commonwealth, draw near, with your attendance, and you shall be heard. I say the Commonwealth of Massachusetts, the court is now open, please be seated.
Good morning, everyone, and welcome to the Appeals Court. I particularly want to welcome my fellow judges, staff members of the Appeals Court, counsel for this morning's cases, and other guests. In particular, I would like to welcome Justice Allen's husband, Attorney Bob Danishevsky, I did my best with that name, and their children, Jack and Spencer. Welcome. Also present today, I believe, are friends of Justice Allen, including Suffolk Probate and Family Court First Justice Janine Rivers, retired Probate and Family Court Justices Randy Kaplan, Kathy Field, and Maureen Monks. Also present are two attorney friends of Justice Allen, who she's recused from, I promise, Attorney Jim Brick and Attorney Ron Stone. Welcome to all of you. It's my great pleasure to welcome our newest member of the Appeals Court, Associate Justice Jennifer Allen. Justice Allen was nominated by Governor Maura Healey, and following her confirmation by the Governor's Council, was sworn in a private ceremony on July 28th of this year. Joining me on the bench today, in addition to Justice Allen, are Senior Justice Ariane Vuno, Justice William Meade, and Justice Gregory Massing. In keeping with tradition, the Appeals Court convenes an expanded panel of 5 justices for the first case to be heard by a newly appointed judge. This ceremonial practice marks the occasion of Judge Allen's formal induction to the court. For the remainder of today's sitting, a 3-judge panel will hear the case composed of Justice Massing, Justice Allen, and myself. A little bit about our newest colleague. Justice Allen is a graduate of Brandeis University, cum laude, and Boston College Law School. She practiced law for 24 years, concentrating on matters before the Probate and Family Court. Her practice included divorce, custody, wills, and estates, but fortunately for us, she also had some experience in residential and commercial real estate transactions and land use matters. In addition, she was often appointed as a guardian ad litem and special master in the Probate and Family Court. In 2019, then Governor Charlie Baker appointed Judge Allen to the Probate and Family Court, where she served with distinction in both Middlesex and Norfolk counties. Justice Allen has also made significant contributions to the broader legal community. She served on the board of directors for Metro West Legal Services, was a board member of the Probate and Family Court, Inn of Court, a frequent lecturer at MCLE, and a member of the Supreme Judicial Court's Standing Committee on Lawyer Well-Being. As you can see, Justice Allen has left an indelible mark on both the judiciary and the legal profession, and we expect she will continue to do so in the years to come. Here at the Appeals Court, we follow the tradition, borrowed from the Superior Court, of numbering judicial seats in the order in which they were created. Justice Allen, you now become the 5th person to hold seat number 12. Guys, play that number tonight in the lottery. This seat was previously occupied by Justice Roderick Ireland, Justice Susan Beck, Justice Mitchell Sikora, and me. I must say, you now occupy a very special seat. Personally, I would like to rename it the Probate and Family Court seat. I should also note that including all statutory and recall judges, you are the 86th person to serve as a justice of this court. So I'm thinking 1286 on the lottery tonight. At this time, I will ask our clerk of the Appeals Court, Paul Tuttle, to read your judicial commission. Clerk Tuttle.
To all to whom these presents shall come, greetings. Know ye that we, by our governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Jennifer M. Allen of Ashland, do hereby, under the provisions of Chapter 211A of the General Laws as most recently amended, and in conformity with our Constitution, constitute and appoint her to be Associate Justice of the Appeals Court, to hold said trust during her good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin her, the said Jennifer M. Allen, to execute and perform all the duties, and she is invested with all the powers and responsibilities which by our Constitution and laws do or may pertain to the said office, so long as she shall hold the same by virtue of these presents. Witness Her Excellency Mara T. Healy, our Governor, and our Great Seal hereunto affixed at Boston, this 12th day of August, in the year of our Lord, 2025, and of the independence of the United States, 249th.
Please join me in welcoming Justice Allen. That concludes the official induction of Justice Allen to the Appeals Court. We will pause for a moment. For those of you who are present for the induction ceremony only, if you would like to leave the courtroom before we call the first case.
I know. It's the original. Must have been changed.
How are you feeling?
Oh, good.
Thank you. Make sure she's still breathing down there. You're still breathing. Okay.
This time, to the first place, case, please step forward.
Our first case this morning is Commonwealth versus Nelson C. Mitchell, docket number 24P 518. Mr. Levchuk, when you're ready.
Thank you, Your Honor. May it please the Court. We have challenged the constitutionality under the Second Amendment of the Massachusetts firearm storage statute.
Can I ask you a question before you start your argument on that? Do you believe that the facial challenge was preserved? Was that raised below?
I believe the motion that was made was broad enough to preserve the facial challenge. I will say, however,
Tell me how.
well, the motion that was filed, talked very generally about how the statute was completely inconsistent in all respects with the nation's historical tradition. It was not briefed extensively, but it was briefed broadly enough to where the argument, it seemed to me, went
So
beyond.
maybe it'd be more helpful if you really addressed it as an as-applied challenge.
I will do so, although I would urge the Court not even to get there. Although we have done the challenge, preserved the constitutional challenge, I believe my friend is correct that, in fact, the Ray's decision from the Supreme Judicial Court effectively precludes this court from reaching the constitutional challenge.
Mr. Love, you didn't include the motion to dismiss in the appendix, so we had to request it. You also don't have a transcript from the motion to dismiss hearing. And Judge Williams said you only made, or Counsel Blow only made an as-applied challenge. I've read the motion to dismiss several times, and there's nothing in there that lends itself to a facial challenge. The word facial doesn't appear in there, None of the telltale signs of striking the law down in its section in its entirety is in there. None of it's not valid under any circumstances. None of that language is in there. It's purely an as-applied challenge in that even the relief you request is just dismissal of his case, not to strike down the statute.
It's true that that's all he requested, but it seemed to me the arguments he made would leave no room for the statute to apply constitutionally.
The problem is you can't raise a facial challenge for the first time on appeal.
Understood. But.
And you didn't include a transcript.
Understood.
Why is that?
That transcript, it was just an oversight, Your Honor.
That's a problem for the appellant.
It is. But for reasons that I was going to get into, which are the McGowan and Ray's decisions from the Supreme Judicial Court, I think you can't reach either a facial or as-applied challenge. In both McGowan and Ray's, the Supreme Judicial Court held that the storage law does not implicate the Second Amendment, that it's not implicated at all because it doesn't affect the ability, excuse me, of a gun owner to possess a firearm for personal protection when it's within their personal custody or control. And having said that, both in McGowan and Ray's, I think this court's precluded from reaching that issue. We're arguing it to preserve it, but simply I don't think the court can, in effect, overrule two SJC decisions. So that's essentially where I am on that. I think the court should reverse the conviction for insufficient evidence. Essentially, what we have here is two officers going into a house responding to a domestic disturbance. They enter the building, encounter the defendant's wife and his daughter. There's a brief exchange, and at some point, the defendant's wife, Tiffany Mitchell, leaves and goes to a separate room, the bedroom. She's there for 2 to 3 minutes, according to Officer Placonico, and then he goes in, encounters her in the bedroom, and sees her, with a shotgun in a bag on the bed.
And you don't dispute that your client is outside drunk?
I'm sorry?
You don't dispute that your client is outside drunk?
He is outside and, I would say, intoxicated.
Okay, so because she has an LTC, your view is that the evidence was insufficient?
For that reason and others. She has an LTC, so when the officer comes upon the shotgun, it is unlocked, but in the possession of someone who is licensed to possess and control it.
Can you give us all the facts that you say she was in possession of that firearm?
In
the light most favorable to the Commonwealth.
In the light most favorable to the Commonwealth, Officer Placonico comes into the bedroom. The firearm, she is standing over the bed with a firearm on the bed in the case.
Maybe we should back up. When the police arrive, she's not in the bedroom, is she?
She is not.
She's in the living room.
She's in the living room.
And there's no shotgun there, so she's not in possession, custody, and control of the shotgun in another room.
She is not. That is true. So, but when she leaves the area where the police are, she is gone for 2 to 3 minutes. Now, in 2 to 3 minutes, we don't know what happened in the bedroom. We don't know where the shotgun was. We don't know whether it was unlocked. It could have
But
been.
we also know that there's nothing in the bedroom that would indicate there was a storage safe or trigger lock or any other mechanism that would satisfy the statute.
Well, yeah, we know that. We do know that. On the other hand, we do know that there was not a search of the bedroom. Officer Burgos, who is the second officer, does not even go into the bedroom, according to his own testimony. He's never more than outside the door. Officer Placonico, when he goes into the bedroom, he gives a very cursory look around. And so there could have been any number of places. He did not do a search or a thorough search of the bedroom by any means.
So to think of what could have been, isn't that looking at the evidence in the light most favorable to the defendant?
Well, it's not in this case because this is circumstantial evidence. And the evidence, when you're convicting based on circumstantial evidence, the evidence has to exclude, it seems to me, the possibility of guilt. I mean, here we have...
That's incorrect.
Well, we have no idea what's going on in that bedroom.
They don't have to exclude hypotheses of innocence.
You don't have to exclude hypotheses of innocence, but where there are competing things that could have happened.
Well, if there was a gun safe or a trigger lock mechanism on the bed, that may be true. But why isn't it in the light most favorable to the Commonwealth a fair inference that the gun was unsecured while she was in the living room and remained unsecured when she went into the bedroom?
Because that's not an inference. It seems to me it's a guess. There's no evidence. In other words, you have to take the evidence in the light most favorable to the Commonwealth.
It's an inference.
But an inference from nothing. An inference from absolutely no evidence.
An inference that there was nothing in the room that indicated she had an ability to secure the shotgun.
That's a guess, not an inference. Because there was no search of that room.
Again, this goes to Justice Massing's point. That doesn't view the evidence in the light most favorable to the Commonwealth.
But you have to view evidence in the light most favorable to the Commonwealth. We are now viewing the absence of evidence in the light most
Isn't
favorable.
it possible that it wasn't secured in the bedroom?
Is it possible? Sure.
Don't inferences only need to be reasonable and possible?
No, they need to have some basis in evidence and in fact, and there's nothing.
That's wrong.
In 2 or 3 minutes, that firearm, anything could have been done to that firearm. It could have been taken out from under the bed, from a closet, from anywhere. You can look at the videos, which have been lodged with the Commonwealth, or lodged with the court by the Commonwealth. And you can look around that room. It is not in a well-kept state, and that firearm could have been anywhere. And what you're doing
Let me ask,
is
if I
saying-
interrupt you for a second, ask you a question. Assuming that we agree that at the time that the police officers walked into the bedroom, that the wife had possession and control of that firearm. But was she authorized?
I'm sorry?
Was she authorized to have possession or control of that firearm? In other words, the firearm is owned by your client, who's outside. Arguably, or maybe not even arguably, does not have possession or control at that time. Right? So just because she has a license to carry and even an FID card, how does that make her authorized over that firearm, to have possession and control over that firearm?
Well, I am aware of no case, and I believe there is none, in which someone with a license to carry a firearm has been found to be illegally in possession of a firearm because the title to the firearm was in someone else's name. I mean, that's just not the law.
Okay.
So I think she is entitled to have that firearm in her possession. But in the end, it still comes down to we don't know what happened in that bedroom for the time she was gone. The officers were there on a domestic. If they had been, they weren't obviously focused on doing a firearms investigation and doing a thorough review of that room. And so, we're just left to guess. And that's why I say I think the evidence is in the light most favorable to the Commonwealth. There's just no evidence, admissible evidence, or even circumstantial
What's
evidence.
your closest case under this statute to the facts, under a conviction for improper storage?
I don't think I have a case like this because I don't think I'll put it to you this way. I don't think this case would have been brought but for the domestic disturbance. This is not a case where the Commonwealth, it seems to me, any case I've seen, would normally charge a failure to store by a violation. This is a case where we have, they're there for the disturbance. Their primary goal is to secure those weapons and make sure they're cleared and not dangerous. And so there's nothing that I was able to find which is like this, which suggests to me that this is sort of out there. And I think the Commonwealth, to its credit, they recognized that this was an issue. I think during Officer Burgos's testimony, I think they argued at one point that this might be a joint venture between Mrs. Mitchell and her husband to try to get in statements that she may have made. And so it's a real issue as to whether, I think they understood it, and I don't think it would have been charged outside the context in which we find ourselves. Going back to the Second Amendment, I'll just note that, in an as-applied challenge, it is a case where this was a firearm of the sort that can be kept in the home for personal protection. And while, as the Commonwealth points out in their brief, in Heller, I believe they said they weren't excluding laws allowing for the securing firearms. In our view, the law in this particular case is applied, sort of well beyond, it seems to me, what the Second Amendment.
This statute is essentially, right, a firearms regulation that is listed presumptively under Heller as a lawful regulatory mean, and I think Rahimi reaffirmed that, right?
Rahimi didn't really go there. Rahimi dealt with.
But Rahimi says in Heller, the Supreme Court's inquiry into the scope of the Second Amendment began with constitutional text and history. That sets the stage for the regulatory list that Heller sets forth as still being constitutional under the Second Amendment.
Well, I don't know that Heller, I would push back on that Heller gave a regulatory list. Heller gave a two-part.
I'm sorry, it was Bruin that gave the regulatory list.
Well, it's not even I don't know that they were seeking to pronounce broad dicta on what is and what isn't constitutional.
Well, I agree, there's not a bullet point list, right? But Bruin's directed the courts to examine our historical tradition of firearm regulation to delineate the contours of that right. So is this a firearm regulation?
Yes, in other words, and that's where.
And is there a SCOTUS case that says that improper storage of a firearm is a burden on a citizen's Second Amendment right?
Not yet. But
thank you for your honesty.
Yeah, it's coming. But I will say, the
Justice Thomas is.
In the opinion here, it says when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Now, McGowan and Reyes found, well, the conduct's not protected or is not implicated. The Second Amendment isn't implicated because it doesn't affect someone's right to possess a firearm for self-defense.
Mr. Levchuk, unfortunately, we're going to have to leave it there unless the panel has any other questions. I want to make sure if Justice Allen has any questions. Justice Massing?
Thank you.
Thank you very much. Attorney Simonian. Maybe you could start off where your brother left off with the as-applied challenge.
Sure. Good morning, Your Honors. May it please the Court, Elizabeth Simonian for the Commonwealth. Beginning with the as-applied analysis here, the Commonwealth didn't take a position on whether or not the issue of the facial challenge or as applied was waived below, but we're ready to brief that. So as applied, we would take the position that Bruin did not overrule McGowan. McGowan is still good law. So when Bruin was issued in 2022, it did not change a thing about the ruling that the storage statute was proper here. It aligned with the defendant's Second Amendment conduct was not implicated. It was not burdened by this statute. There was an entire analysis that McGowan went through. They looked at Heller's presumptively lawful regulatory measures. They looked at firearm regulation laws, which have always been held to be constitutional. And looking at prong one specifically, the defendant's conduct here falls outside the scope of the Second Amendment. He was intoxicated in his backyard. He was not carrying that firearm. He was neither keeping it within his immediate possession. To keep has been interpreted by Heller as to have. It's been interpreted by McGowan as to keep immediately within one's control. That's not what the defendant was doing here, so that's not protected.
I'm sorry, You said this again more slowly, the to keep thing. Could you just
Sure.
repeat that?
Heller has interpreted to keep as to have. McGowan has interpreted to keep as to keep immediately under one's control. So when looking at the defendant's protected conduct, that would be to have 3 lawful firearms, which he did. However, the protected conduct does not include the defendant being drunk outside in the backyard while his shotgun is unlocked in his home. So on prong 1 of the Bruin analysis, the Commonwealth would argue that the defendant's conduct here falls outside the scope of the Second Amendment, and I
just want to press you a little bit on that. The Bruin analysis is, does it fall outside the scope or does it fall outside the text?
It would be the text. So the Second Amendment's plain text must cover the defendant's conduct here. Like I previously said, it would be to keep or to carry. So the defendant's conduct.
Keep and to bear.
To keep and to bear, but bear has also been interpreted as to carry as well.
He's keeping it in his bedroom.
Unlocked. And the whole the point that McGowan makes here is there's 2 exceptions to the Massachusetts storage statute. When someone is neither carrying or keeping it immediately within their control, they're required to lock it up. And here, that's exactly what the defendant was supposed to do. He was required to lock it up. Now, that goes to the...
Does it matter whose shotgun it is?
It matters whose shotgun it is for purpose of proving the second element that of improper storage, and that would be that the defendant knowingly kept or stored the shotgun. So here, the Commonwealth, on a side note, with the sufficiency claim, they used ownership to prove that he knowingly kept or stored that firearm.
You don't dispute that his wife had an LTC?
No, his wife did have an active LTC.
She was in possession of the shotgun?
She was in possession of the shotgun at the time it was recovered. And that's where the reasonable inference comes in here, is that the Commonwealth's entire case, and in the light most favorable to the Commonwealth, the case rests on the inference that while the defendant was in the backyard, and while...
No, I'm not talking about sufficiency. I'm talking about the as-applied challenge.
Yes. Okay. So you asked about ownership, but can you clarify in terms of ownership as applied?
I mean, the Second Amendment doesn't say you can only keep and bear arms that you own.
No, not necessarily. She was allowed to possess that firearm. It's just that the case rests on the inference that it was before the fact. So we're not looking at her conduct of keeping and carrying. The defendant's the one who's charged here. The defendant is the person who was improperly storing that firearm, and quite frankly, the wife was the victim in this case. So it's a charging discretion with the prosecution.
You're saying that the crime occurred when no one was in the bedroom with the unsecured...
Correct. That's exactly when it happened. From the evidence, we can draw that inference. So looking
I'm sorry, go ahead, Justice Smith.
Just briefly on the facial challenge, didn't it pique your curiosity when Justice Williams said that it was only an as-applied challenge?
I did. It was interesting that she only allowed the defendant to bring an as-applied challenge, but besides the point, even...
I mean, for the standard of review, it's critical. And your brother didn't provide a transcript, and we had to request the motion to dismiss.
Correct.
When someone's making a challenge on appeal for which appears to be the first time, and doesn't include those types of documents, it makes me think that maybe something more is going on here.
I understand.
Maybe I'm more suspicious than you are.
I understand. The reason why the motion judge's decision to not allow the defendant to bring the facial challenge, it was harmless to this case.
No, she didn't say he wasn't allowed to bring it. She said he did not bring it.
Okay. I apologize. My interpretation of that is that he was not permitted to bring that.
No, she says the court finds that the defendant's challenge to the charge is limited to an as-applied analysis.
Okay.
Paragraph 8.
So only an as-applied analysis was brought, but it's not harmful that the facial challenge wasn't brought here either. Because even on appeal, when we look at that, looking at the facial challenge fails. And where the facial challenge fails, the as-applied challenge also fails. And this court recently issued a case to dispense with the facial challenge recently. I believe it was last week, Commonwealth v. Robert Brown. There was a facial challenge.
A 23.0 or a full opinion?
It was a 23.0. I can file a 16L letter if this court would like, but in...
Is it preserved in that case?
No, because in that case, there was no pretrial Bruin motion filed in this case. We had a pretrial Bruin motion that was filed. It was also orally renewed at trial. So this Second Amendment issue was preserved.
You can preserve an as-applied challenge at a motion required finding, but you cannot preserve a facial challenge absent a motion to dismiss.
Okay. I understand. In terms of but still looking at the first prong, the defendant has not satisfied his burden here. He has not shown that anything he was doing, he was protected conduct. That's his burden to show. Prong 1 of the Bruin analysis, the defendant is required to show that his conduct falls within the plain text of the Second Amendment. He's not done that here. Even assuming he can show that his conduct falls in the plain text of the Second Amendment, he still fails on the second prong. This is a storage statute that's been, hasn't been around nearly as long as other storage statutes, but it's nothing new. All we need is a law that's relevantly similar here, not a historical twin. And Heller references 1783 mass regulations on the possession of gunpowder and loaded firearms in dwelling houses, the purpose to prevent accidental fires. They also discuss the 1746 mass prohibition on the indiscreet discharge of firearms in Boston. This is nothing new here. This statute aligns with this nation's history and tradition of firearm regulations.
Is there a historical tradition for trigger locks?
I haven't seen a law for trigger locks, but we have cases that say back then, where the gunpowder was required to be kept separate from the firearm. Even a skilled soldier, it would take time to unlock or to load the gunpowder in the shotgun or the musket, fire it. And now these safes, you can do a lot with these safes. You can open them within 40 seconds. So I would argue that although it's not, the law now is not exactly like the previous laws, or there may not be one around from back then, it doesn't necessarily matter because we have relevantly similar laws out there. If there are no further questions on the constitutional
One more. You agree with with Attorney Levchuk that we shouldn't reach this issue?
That we should.
That we can't reach this. That we can't overrule
No, we
McGowan.
can't reach this issue. The SJC has already issued 2 cases that address this issue, and again, Bruin did not change a thing, and there's already an analysis, and like I said, in
And even if Bruin did change a thing, could we say, oh well, the SJC didn't have the advantage of Bruin, so we can look at it new?
No, unfortunately not. It would be up to the SJC to say something about that.
So I have a sufficiency question for you
unfortunate.
and a hypothetical.
Sure.
Same exact fact pattern, except the police arrive and find the wife in the bedroom with the gun. That's the first time they see the gun with the wife in the bedroom.
Okay. She would be in possession or control of the shotgun at that time.
So no crime.
It would appear that way.
Is she an authorized user?
She's an authorized user for the purpose of having an LTC as well as an active FID. And again, I do agree with my brother. I haven't seen a case out there that would charge someone with improper storage where there is somebody possessing the firearm at that time, but that's not what this case is.
So when the statute says lawfully authorized, you say that refers to authorized by the law and not authorized by the owner of the gun?
It would be authorized as in having a license to carry or a firearms identification card. But here, that's the hypothetical. Here, we have officers who, when they walked into the home, they're speaking in the living room. The wife and the daughter are speaking in the living room with police, and the defendant's outside. He's not in control or possession of that shotgun. The wife is not in possession or control of that shotgun at the time that she's speaking with police.
So on page 18 of your brief, I just want to make sure this is the entire constellation of facts that you say suffices in a light most favorable. You say a rational fact finder could draw the reasonable inference that prior to the officer's arrival and before wife entered the bedroom where she was found with the defendant's unlocked gun, the defendant, who was neither carrying nor in control of his shotgun, had not properly secured it as required by the storage statute. That is the entire constellation of facts for this crime, correct?
Yes, and then So my brother attempts to disprove the fact that he was required to lock the shotgun by using the wife saying she was in possession or control. When here, the facts show that because the case rests on the reasonable inference, the defendant was required to lock or securely store his shotgun. So we know that he's required to lock or securely store. So the requirement of not locking or securing it cannot be disproved because the wife wasn't in possession at the time that we are talking about. So now that we know that he was required to lock or securely store his firearm, we look to the testimony of the officers. And we have one trooper and then 2 Springfield police officers who both testify when the night in question, there was no gun lock on it. It was different from the time at trial because there was now a gun lock on it. And then we also have Officer Burgos who testifies there was no gun safe in the room. This room is pretty small, so we can see that from what they're testifying to and the body-worn camera footage, there's no secured container. There's no lock on the soft gun case. There's just nothing in there to suggest that this defendant did properly lock his shotgun.
So could,
Justice Allen?
could the wife have been charged with improper, with the same statute?
I think that was a charging discretion. She was the
I mean, she could have
victim in
been. She
this.
could have been.
So on that's where ownership comes in, I believe, is because it's not her firearm. Yes, she's lawfully using it, but she doesn't own it. If we look to McGowan, similar facts as McGowan, we have a domestic dispute, but the victim throws the defendant's firearm outside into bushes, the defendant goes to retrieve it, the firearm is loaded. So but the defendant was charged there. It was his firearm, it wasn't the victim's. So similar here, it's the defendant's firearm, it's not the victim's firearm, and that comes, I believe, with charging discretion as well. They're not going to charge the victim here.
I believe Justice Allen has a question.
Sure.
On the issue of control, it comes down to the authorized user being sufficiently nearby to prevent immediately unauthorized use.
Correct.
So sort of expanding on Justice Blake's example, what if when the police officers arrived, I believe the door was unlocked and they could see into the bedroom that she was in there, and then she left the bedroom and came out to greet them, and then they immediately went back. So she just did a traverse the house. It's a very small house.
Yep.
And I think it was just 2 rooms away. What would you say in that?
In that, it's because, I mean, if she's walking away from it and it's unlocked, improper storage, defendant's firearm, but there's no bright line rule that can be really drawn in these types of cases. It's a fact by fact circumstance, and that's exactly what Patterson, out of this court, 79 Mass App Court at 319 says. We have to determine based on the firearm's location, the proximity to the owner, and that person's ability to reach immediately the gun. So different hypotheticals are going to play out differently depending on where the firearm is, where it's located. In that specific case, it depends, honestly. I can't say for sure whether or not who the Commonwealth charge, if the Commonwealth would charge there, but in the light most favorable to the Commonwealth here on the facts of these case, I would suggest that the defendant nor the wife was in possession or control of the shotgun while he was in the backyard and she was in the living room. If there are no further
Well, your time has expired, but let me check with the panel to see if there are any additional questions. Seeing none, the case is under advisement. Counsel, thank you both very much. The court will
you.
take a very brief recess to reconstitute the panel.